Everybody, today is just a very last minute live stream, mainly for the purpose of showing you Donna Adelson's latest filing, which is with the Florida First Court of Appeal. So you guys may recall, I think it was just a couple of weeks ago, that her motion regarding Judge Everett's refusal to recuse himself, she appealed it. That was quickly denied. But instead of taking no for an answer, she has filed this additional motion for a rehearing. And I can't vocal injection 3 weeks ago, and it's helped a little bit with the shakiness, but in terms of voice quality and strength, it's still not good. So let me just scroll through this and highlights. Panel of First District Court of Appeal judges to hear this. She says the panel decision clearly overlooked or misapprehended a key fact and the main reason behind the objective fear that Mrs. Adelson has when rendering this decision. Specifically, the decision focuses purely on one aspect of Mrs. Adelson's amended motion to disqualify the Honorable Judge Stephen Everett and neglects the actual harm or fear of future harm caused by that aspect. She says it's of exceptional importance that requires the consideration of a majority of the judges within this court. Public trust in the justice system would be eroded. Talk about the fundamental protections guaranteed by the state and constitutions. So this is followers of the case know. Seventh this year, the state disclosed a flash drive that contained numerous pieces of discovery about their first motion to disqualify the judge on April 11th this year. Judge Everett denied it, finding it legally insufficient. Additional discovery, so Donna's attorneys filed a second motion to disqualify. 2 days later, Judge Everett again denied the motion to disqualify. So May 9th was when Judge Long, along with Judges Rowe and Bilbrey, denied her petition, finding that the claims within her petition were meritless and facially insufficient. So they're claiming that the Court of Appeal behind the objective fear that Mrs. Adelson has when rendering the decision. As a result, rehearing is required. or missed a central argument raised. Of law enforcement or its agents having ex parte communication with a judge for purposes of obtaining search and or arrest warrants. However, this motion is being filed because the decision falls short by failing to recognize that the ex parte communication in this case do not fall within the recognized legal authority noted. A simple ex parte communication between law enforcement and a judge for a warrant is not what transpired in Mrs. Adelson's case. So this is kind of strange that they're saying without any notice to the defense. Well, as other legal commenters have noted, that's the point, is that the defense isn't supposed to have notice when new warrants. So now they're claiming that these serious allegations were clearly considered at the time of Judge Everett's ruling on Donna's pending motions. Specifically, Judge Everett considered the false information learned at the hearing on the motion to set bond. Donna's attorney had been able to know about this knowledge, then they would have been able to argue against those false allegations from the confidential informant, abbreviated as CI. They could have provided the judge with proof of the informant's lengthy criminal record, which included numerous felony convictions and crimes involving dishonesty, and ensure that no further harm came from the allegations. I can make sure people can actually hear this since I can't talk loudly due to my medical problems today. As usual, the issue is the timing in which those communications were had. More importantly, it is about the impact those communications had on the trial court when ruling on issues directly related to the very matters in which the court had learned ex parte. Well, I don't know. I came through this, I'm kind of in a rush, but I have some commentary about that. Proof of such is contained within the face of the record, including the mention in the order denying Mrs. Adelson's bond. Also to prepare for trial. This information was relayed to Judge Everett during the ex parte communications with the very investigator in Mrs. Adelson's case, who will ultimately fight against her at trial, which will be presided over by Judge. Law enforcement who's going to testify against her. There's absolutely nothing in the record about the amount of time that Mrs. Adelson has spent speaking to counsel on the phone about her case, or the amount of time or number of visits that Mrs. Adelson had with counsel at the Leon County Jail. I don't know why that about the record evidence of the interaction and the resulting impact of such. The fact that one party was able to have unfettered access to the presiding judge on a pending case and provided them with information that was clearly intended to create a bias against the other party without providing the other party with an opportunity to be heard is inherently unfair. Well, I mean, talk to him in order to get the warrant, though. So, I don't know. I mean, other attorneys, Johnson or other people who practice criminal law in Florida have said that that's totally normal procedure when a warrant needs to be issued. Error with the current decision is that it does not contain a single hint of considering this critical distinguishing facts or these grammatical error there, and whether those facts would have provided a facially sufficient reason to seek disqualification in this case. The very law cited by this court in the current decision requires disqualification of Judge Everett because if the communication was authorized as found, then there would have been no reason not to notify the defense and provide them with an opportunity to be. It's interesting because that kind of goes against the purpose of getting a warrant. You don't want to alert people ahead of time that there's going to be a wiretap. So nobody ever noticed Donna's attorneys of these ex parte communications in violation of the law, they argue. Not receive a fair trial under the authority of Judge Everett. These false allegations were very damaging. And, quote, at this time, Harvey Adelson is the most frequent caller for Donna Adelson, but it is apparent Donna relays information to Harvey through attorney privilege calls. These calls are not monitored. Phones have played a critical role in this investigation. Harvey Adelson, during this entire investigation, and the one he still communicates with Donna on, this order is being requested to determine any patterns with privilege calls that cannot be monitored, as well as any potential threats that may be orchestrated. After court, if she had any comment about this allegation that the affidavit was based on false allegations. And she denied that with this assessment that Donna's lawyers have made. Affidavit. The state alleged that a jailhouse informant alleged Mrs. Adelson was offering to pay for witness testimony. The affidavit continues as follows. The phone records for Harvey Adelson were reviewed along with jail phone call records and dates and times for attorney visits. There are overlapping communication records between Harvey Adelson, the defense attorney's cell phone, and attorney visits. It was also learned that Harvey Adelson has changed carriers from AT&T to Verizon since the issuance of the previous order. As with the December 19th, 2024 affidavit, the undersigned counsel has also already determined factual assertions made in the January 9th, 2025 affidavit to be false. Okay. I prove this instead of continuing. Sorry, gotta go soon. And suggested that two attorneys in good standing with the Florida bar were planning to present false information on Mrs. Adelson's behalf or potentially tamper with witnesses, all of which have proven to be false. The poll cited in the current decision is legally correct. It does not accurately address what transpired in this case. False information provided, or the impact that said information has had or could have in the future on Mrs. Adelson's case. Failure to consider these critical portions of this issue must be remedied through a rehearing. Footnote: not only have certain allegations involving both Mrs. Adelson and the defense been proven false, but the actual supporting records that were offered to support these claims were also proven false, such as visitation records and phone logs. Suggestion proposed by the application concerning Mrs. Adelson with counsel are not only reckless but deeply offensive and undermines the proceedings entirely. Okay. All the members of the court to reconsider the issue. Current decision to stand presents a loophole that invites abuse without firm boundaries and accountability. Here is that actors who seek to manipulate the judicial process in the future will exploit exceptions to the prohibition on ex parte communications as a backdoor to improperly influence the court. To stand continues to uphold the harmful precedent that allows this unconstitutional and shocking behavior. As a result, the undersigned asks that this case be reheard That is signed by Rachel Reese, Donna Adelson's appellate attorney, and I'll try not to show people's phone numbers and addresses because that's against the YouTube policies. Okay, so that's pretty much it. Unfortunately, I do have to get going to a meeting, and I think it sounds kind of, I don't know. I mean, what do I know? I'm not a criminal attorney. I don't practice in Florida, but I do feel that this is their dogged determination to just go for any and all potential legal arguments they can possibly make and potentially postpone Donna Adelson's trial once again, which I sure hope isn't going to happen. I don't know how quickly the first Court of Appeal can respond to these types of motions, but usually, I mean, you would think it would take at least a couple of weeks, maybe even more. Have a case management hearing that is scheduled for June 11th. Donna's motion to transfer venue is June 13th. So there's more stuff that's coming up in her case. So hopefully the Court of Appeal can quickly schedule some sort of hearing if they are going to do that. So she's pulling out all the stops to just fight. As Jackie Fulford said, she's fighting for her life. So you can't blame the attorneys for filing all this stuff. I mean, they're trying to make some good arguments, but I think it sounded like it was pretty well established law that it is okay for the judge to have these types of ex parte communications for the purpose of signing warrants. So it doesn't make any sense that Donna's attorneys should have been alerted first to be able to be there to argue against these allegations. Sort of reminds me of the was arrested at the Miami airport. She was finally sitting in the police car, and she said, shouldn't they have told me or given me notice first about the warrant? So it kind of reminds me of that kind of entitled attitude that Donna Adelson had, that she feels like she should have been told and she's going to fight with every bone of her body. That's from an email. Judges of the First District Court of Appeal. I don't know any of these people. I'm sure attorneys like Tim Jansen and Jared Frost would probably have some good commentary to provide, since Jared has mentioned publicly that his wife is an attorney who specializes in criminal appeals. They're both in Tallahassee. So I'm sorry I have to get going. Sorry to what a negative commenter said to me yesterday. I do have plenty of legal work and my law practice is doing great. I just settled a case that was scheduled for a bench trial yesterday, and I'm in the process of settling another case. I have court tomorrow, followed by the rest of tomorrow. So I do have to, unfortunately, save my voice, but I do appreciate you all being there and still tuning into this channel. My goal is to provide good information. So apologies again for the weak voice. Hopefully it'll be better by Saturday night when I have a live stream with law professor Joe Patuto, and we will be going over all the latest news in the Dan Markell case and Donna Adelson case. Thank you guys. Really appreciate your support. Have a good day. Thank you.